not elicit new evidence that is not already in the record. I or a panel member may ask a party to support his or her oral argument on a particular matter by making a specific reference to a citation in the record. At the end of oral arguments by counsel, I will offer Dr. Lee an opportunity to address the panel regarding penalty if he desires to do so. And if he does, then I will place him under oath, and he will have no more than 5 minutes to address the panel. And then after oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving a decision later in the mail. And I should say after argument and any comments by Dr. Lee, the panel will have an opportunity to ask questions. Oral arguments are being recorded stenographically by a court reporter who, of course, is at a different location than those who are speaking. Therefore, it's important that everyone identify himself or herself each time before speaking, and that they speak slowly and clearly. We ask that you mute your microphone when not speaking, and of course, remember to unmute it before speaking. Also, keep in mind that the rustling of papers can be picked up by microphones when your microphones are live. Again, I want to remind the parties that all arguments must be based on the existing record and no new evidence will be heard. Additionally, the board has had the benefit of reading your briefs. And with that, Ms. Hendrickson, if you would like to begin.
Yes, thank you. I want to say good morning to everyone and thank you for the opportunity to be heard on this matter. We're here today because the issue in this matter is whether or not a penalty should be imposed. As you all know, the ALJ heard the matter over the course of 4 days and determined that a penalty should not be imposed and that the accusation should be withdrawn. So I kind of want to reiterate for you how that decision was made and what happened over the course of those 4 days. So to begin with, the medical board did not meet its burden of proof, and that's really what's at issue here, that the evidence, the record did not show that the medical board met the burden of clear and convincing evidence. Now, I want to kind of discuss each day and what happened. On day one, we heard from the medical board's expert. The medical board's expert was extremely confusing, cagey. One of the things that the medical board made in its written brief was that it stated the issues in this case are actually quite complex and cannot be explained in simplistic terms. I actually disagree with that statement. The issues in this case are simple. And what happened was that over the course of the medical board's experts' testimony, it was confusing to really decide what is she trying to say. Oftentimes her testimony would change. She would say one thing and then say, well, yeah, but I didn't consider that, or I did consider that. The medical board is trying to say now that he was incompetent. Not only is that not in the accusation, but this is based off their medical expert saying, well, if we were to believe the mother. But yet in her own report, she says she didn't believe the mother because of so many inconsistencies. So at the end of it, I would like to go through, and I did this in my brief, but I just kind of want to reiterate the point of each one of the issues that she found and why we don't agree with her findings. So documentation and history. Her basic point is that we need to have qualifiers. There is missing information in the chart. For example, where is the location of his back pain? That is one thing that she tried to say. But yet, if we go to the physical exam, we see that the back pain is in the lower back. So she's saying, well, it should have been in the medical history. It was in the chart, is the point. She's saying, well, there's missing information, for example, a family history of diabetes. 2 medical providers spoke with the patient and a mother. The first being the patient himself, and the second being Dr. Lee. And neither one of them documented that the patient had a family history of diabetes. Now, the mother wants to say over and again now that she did tell the physician this, but yet two providers are saying, no, if this was told to me, I would have documented it. The mother's testimony herself is, respectfully, she lost her son and she's upset. And we understand that this was a tragic case of a 16-year-old boy that shouldn't have died. That's just the fact of the matter. He shouldn't have died. It's not fair. But at the same time, the information she's telling is constantly changing. One moment she tells us that Dr. Lee she tells the investigator, Dr. Lee asked what he had eaten that day. At hearing, she says, no, that never happened. He never asked what I ate. So I understand she's upset, but memories fade. So while she wants to be adamant that she told this information, the truth is she doesn't remember a lot of what happened. But what we do have is the medical records, and we have two providers who didn't document. The expert next said, well, let's see, that there was documentation in the physical exam that was inadequate because she found that simply checking the boxes was not enough. So the problem here that we have was bias from the board's expert. She has used this particular form in the past, so she's familiar with it. She worked at urgent cares. And she said, well, you need to add qualifiers. You can't just check positive or negative. And in fact, she even stated at one time during the hearing that she didn't believe the information in the chart because she can't assume that he actually checked those, that he actually examined those systems because he only documented negative or positive. Had he actually added more qualifiers, then she would have believed that he actually checked those systems. So that's huge. There's a lot of assumptions on the part of the expert. There was also, she talked a lot about the heart exam. Now, one of the problems that we have, because the issues were made to be quite confusing, is there's a lot of, well, he should have talked about the sinus rhythm. He should have documented the heart rate. He should have noted an improvement in the heart rate. All of these are one issue, the heart exam, and whether or not Dr. Lee's heart exam was within the standard of care, not this documentation, that documentation. It's all one issue. So let's talk about the heart exam. This patient came in with a elevated pulse. We all know that. So why was there no documentation in the chart of improvement? Well, there was two documentations. The first being the actual exam itself. Dr. Lee noted that the heart rate was normal. Okay, why did he document the heart rate was normal? Well, because this is a grossly obese patient, 378 pounds, I believe, who came in. It was 100-degree day, August in Sacramento. He was in a lot of pain, 10 out of 10 pain, he reported. He was nauseous. He had just vomited right before his vitals were taken. And he was hunched over. There was a lot going on with this patient. And so Dr. Lee then checks his heart rate, and he finds that it's below 120. And so the question is, well, is a 120 or below normal in an obese patient with this presentation? And the answer is yes. Even the board's
interpose an objection. May I interpose an objection?
You may.
Okay, sorry. I believe she's stating evidence that is not in the record, claiming that Dr. Lee found a heart rate under 120. I just interpose that objection.
Ms. Hendrickson, your response?
It's in his interview, and he testified to it, Your Honor.
Okay. Ms. Wagner, anything further?
No, Your Honor. I'll save it for my argument. Thank you.
Okay. So the objection's overruled. Ms. Hendrickson, if you please continue.
Thank you. So the question then is, well, is up to 120 normal? And both the medical board's expert acknowledged that it would have been for a patient with this presentation, as well as Dr. Lee's expert said the same thing. So then the question becomes, well, how do we know that? Shouldn't he have documented some sort of improvement in the heart rate? Yes, he should have, and he acknowledges that. Repeat vitals should have been taken. He understands that. Dr. Lee had a policy in place. Part of what wasn't in the ALJ's decision that was in the record is that these medical assistants go through a lot of training at his office. And so with the training in place, with the fact that this medical assistant had been working for Dr. Lee for several years, he had no incidents before that with this medical assistant. He had no reason to believe that repeat vitals wouldn't have been taken. It was a documented policy in place. And so, should he have documented improvement in the heart rate? Yes, repeat vitals should have been taken. It's one issue. It's not separate issues here. We're talking about a diagnosis of dehydration. Their expert over and over again reiterated the point that dehydration should have been diagnosed in this patient. However, Dr. Lee, the patient comes in with possible symptoms of dehydration, and dehydration is on Dr. Lee's differential diagnosis. However, he then performs a physical exam, and on his physical exam, there are no findings of dehydration. The mucous membranes are normal, the eyes are normal, skin turgor is normal. There's no evidence of dehydration. So while the medical board's expert insists that dehydration should have been included in the diagnosis, there was nothing on the physical exam to corroborate that, which is why even though it was initially on his differential, it eventually was dropped from his differential and not ultimately his diagnosis for this patient. Orthostatic vitals was another issue. This patient came in with 10 out of 10 pain. He's almost 400 pounds. Doing orthostatic vitals is nearly cruel, frankly, in this case. It's an outdated test that most providers don't even do anymore because it's so unreliable. And in fact, the expert even said that had his, actually, I withdraw that. Next is urinalysis. There's a lot of discussion on why more testing wasn't done. Why wasn't a urinalysis done? Why wasn't blood work done? And this is a huge part of this case. And the answer was, it wasn't indicated. Dr. Lee testified at hearing that he went through the medical history with the patient. He testified that forgive me, I'm trying to open a screen really quick. I apologize. All right. So I asked him during the hearing, what did you ask the patient when you saw him? And he said, quote, I looked at the chart and the chief complaint for him to come is back pain. So typically ask, where is the pain? How long the pain has been? Anything make it better? Anything make it worse? And what kind of pain? Sharp or dull pain? Whether the pain is constant or comes and goes, and how much pain he has from 0 to 10. I ask him associated symptoms, review of systems, fever, chill, cough, abdominal pain, nausea and vomiting, or diarrhea, urinary systems, burning, frequent urination, any injury to the back, any pain in other body parts. These are all questions that he asked the patient. And we can see in the chart that there's documentation answering these questions. There's then the question of, well, why didn't he document no urinary complaints? Why didn't he document everything here, the entire review of systems that's on the right side of the chart? And the answer is because it's not his custom and practice. What typically happens in his office is this. Typically, the medical assistant takes the patient's vitals, then asks about current complaint, and asks about everything on the left side of the chart, which is, why are you here? What's your pain level? How long has this been going on? All of which is in this chart. Medical history, anybody with associated, any injury. Then what happens is on the right side of the chart, it's a pre-printed form and it shows a review of systems. Typically, the medical assistant will go through this review of systems one by one. In this particular case, it wasn't done. And so the question becomes, why wasn't it done? And the answer, we don't know for sure, but what the evidence in the record was this. Dr. Lee had seen the patient go to the bathroom. He heard him violently vomiting. The patient then came out of the bathroom, went into the exam room. Dr. Lee then finished up what he was doing and testified that he went into the room. That is not typically what his practice is. Typical practice is that the medical assistant would come out of the room, put the chart on the door, and he would look at the chart, see that it's all filled out, and then go into the room. In this case, he went into the room. So the insinuation, and we don't know for sure, was that he interrupted the medical assistant while he was taking his history. The medical assistant then handed Dr. Lee the chart, and Dr. Lee then went through the history again. So on a typical occasion, this would have been filled out. Now the question then is, well, is that the standard of care? No, the standard of care is to do a review of systems, which was done in this case. A review of systems was done. We have the complaint. We have a history of the complaint. We have pain levels. We have frequency. We have the amount of pain the patient was in. All of those things are documented. So that is where the standard of care is. Now, would it have been better to have more information? Absolutely. Nobody disagrees with that. More information would always be better. But this can't be a case of hindsight where the patient died and now we're looking backwards and going, well, you should have asked about urinary system, or you should have documented no urinary symptoms. If we were looking at something else, this patient was paralyzed because he came in with 10 out of 10 pain and Dr. Lee didn't order imaging, then that's what we'd be discussing. Why wasn't imaging ordered? My point is, we can't look at this as a case of hindsight. We have to look at this in real time. What did the patient present as? What did Dr. Lee have in front of him? Now, the next question, well, how do we know he asked all these questions? The mother corroborated it herself. She told the investigator that he asked what the patient had eaten that day. She said that to the investigator. Now, she might have not said it at hearing, but the mother's memory
Ms.
is...
Hendrickson, you've reached 15 minutes.
Okay.
So, Ms. Wagner, your opening argument?
Thank you. The board in this case did prove the matter by clear and convincing evidence. And there's two main points I want to make sure and reiterate to the board today. Number one, the proposed decision does not accurately reflect the evidence that came before the board. And number two, the proposed decision is inadequate to protect the public in this case. 16-year-old patient came to see Dr. Lee and he was desperately ill. He came with his mother. He was so weak, he needed help getting out of the car. He needed help walking inside of the urgent care. He was vomiting quite actively. He was so suffering from such excessive thirst that his mother had to stop on the way to the urgent care to buy him a gallon of water, which he guzzled down and still brought into him in the urgent care to be treated, and had that water with him when he was with Dr. Lee. He had every single vital sign there is. All four of them were abnormal. He had 142 pulse rate. His blood pressure was 164/94. His respiratory rate was high, and he had a low grade temperature. All of the vital signs that were checked, all abnormal. He also had the severe back pain, 10 out of 10, and the nausea and active vomiting. He also had symptoms of dehydration, vomiting, diarrhea, the fever with an elevated heart rate. And despite all of these very serious symptoms, the constellation of all of the abnormal vital signs, respondent did not give the patient a simple blood test. He did not give him a urine test. He did not take and document repeat vital signs. The records show that his pulse rate was 142. That's what the records still show. Either he didn't take repeat vital signs or he didn't document it. But there's not any in the medical records of the urgent care records. He also did no fluid challenge and took no orthostatic vital signs. The patient, who later had to be hospitalized within 9 hours after being seen by Dr. Lee, All he did was give him a shot for the back pain that he hadn't yet to figure out was what was causing that, a 10 out of 10 back pain. And he prescribed anti-nausea medication that the mom had to pick up at a pharmacy outside of there. He diagnosed the patient with food poisoning and non-infectious gastroenteritis without any documentation in the medical records as to why he believed it was food poisoning. What had the patient eaten that could have caused food poisoning? Did any other family members have food poisoning? The medical records in this case were severely deficient. As I've already indicated, there was no repeat vital signs prior to the discharge documented in the medical records. There was no documentation that the patient's tachycardia had resolved. There was no documentation regarding what the patient had eaten, as I indicated earlier. So the teenager was sent home with his mother, so weak he could barely walk out, actively vomiting, with all of his vital signs abnormal, and told to go home. He went to the hospital within 9 hours, and he died within days of complications of undiagnosed diabetes. And this was despite the fact that, as the mother testified at the hearing, Dr. Lee was told that her other son had diabetes, that the patient's father had diabetes, that there was a family history of diabetes on both sides of the family, and that she had high blood pressure. It was despite the fact that the patient had excessive thirst, and he was drinking right in front the water in front of Dr. Lee. And instead, Dr. Lee told her that the back pain was from the patient throwing up so much, and that was what was causing it. He also implied at the hearing that he just simply believed that because he was overweight, that was causing the back pain. And I think he also said the higher blood pressure. The mother's testimony in this case, which disturbingly is not described at all in the proposed decision, not even mentioned that she testified, much less that the testimony was evaluated or compared with any of the other evidence that corroborates her testimony. Her testimony is essentially uncontroverted as to many of the facts because Dr. Lee doesn't remember what happened, and the medical records don't show the things that the assumptions they're making about what did happen. For example, the most serious, that Dr. Lee believes that the heart rate must have dropped to 120, or he would have documented that. But there is no documentation that anybody even took a repeat vital, nor is there any documentation of what that repeat vital was. And even if it was 120, 120 is still an abnormal pulse rate. So her testimony, my point being, is essentially uncontroverted because Dr. Lee doesn't remember what happened. And yet, incredibly, the proposed decision does not assess the mother's testimony or even say that she testified. Excuse me, I'm doing the page turning thing. So the board's expert testified, and it seemed that both the judge and counsel, as they indicated in their argument, very much attacked the board's expert based on style issues, whether they thought her report was written a certain way or how she testified. She had never testified before in a hearing. She was not a professional witness. She's a doctor, and she tried to listen to the questions and answer them the best she could with her information. But you can tell by just looking at Exhibit 7, the urgent care medical records, how seriously deficient the treatment and care and documentation was in this case. There's extreme departures for failure to document related to the standard of care. There's multiple departures in this case, many of them extreme. And of most concern is the failure to consider cohesively that every vital sign was abnormal and that there was significant tachycardia in this case that was not addressed. In addition, there is concern that both of the experts acknowledged that Dr. Lee seemed to think that the temperature could be explained based on the heart rate, as if the temperature made the heart rate higher, which is a lack of knowledge and shows a violation of the standard of care for Dr. Lee. And yet the proposed decision essentially disregards the expert's opinion or testimony as on superficial reasons, over style, over substance, and faulting her for not testifying before. The respondent's expert, on the other hand, is a highly polished, highly paid professional witness who, as Exhibit 16 shows in the record, was highly edited in his report with great consultation with counsel as to what the report should say and how it should be phrased and how many departures there should be, until he crammed all of these problems with the treatment in this case into one single simple departure regarding lack of documentation. But even he agreed that the documentation was deficient. He was forced to base his conclusions regarding that based on what Dr. Lee must have done. He must have done a repeat vital, and he failed to document. Even though it doesn't say that in the records, and even though 120 would still be abnormal, even if we believe that. The proposed decision isolates one phrase from the board's expert and attaches great significance to the issue, claiming that the board's expert didn't understand the standard of care and didn't testify properly about that. And that's simply not true. And we've documented all the things the board's expert said, both in her testimony and in her report in our brief, if you should choose to review that. There are extreme departure based on the fact that all the vital signs were abnormal. He did not take a repeat heart rate. He did not ensure that the patient was stable. And the medical records are an extreme departure all by themselves for the standard of care. Medical records is not like a technical violation. They are an important part of the standard of care that's given to a patient. And yet, despite all this overwhelming evidence, the proposed decision finds no cause for discipline and dismisses the accusation. The medical records alone are very seriously inadequate and are a key component of the standard of care. The proposed decision ignores the weight of evidence in this case, and we do believe that cause for discipline exists. The disciplinary guidelines in this case, in a case like this, would call for 5 years of probation. Because this is a single patient case with no prior discipline, we are recommending instead 3 years of probation, a practice monitor, a clinical competence assessment program, medical record keeping, ethics, and education. And these are requested in order to protect the public. As we sit here today, we have no idea if Dr. Lee has improved his record keeping, for example. There's no there's no practice monitor been in place. There's no record keeping monitor in place. The ALJ seems to be very impressed with the fact that eventually Dr. Lee did take a medical record keeping course, but based on the care that was provided in this case and the concern for the public protection, it seems that the only appropriate decision is that discipline is appropriate. The board has proven this case by clear and convincing evidence, and that 3 years of probation with all the usual monitoring would protect the public in this case, and that the proposed decision simply did not accurately reflect the weight of the evidence that was admitted before the board. Thank you.
Thank you. Ms. Henriksen, your response.
Yes, thank you. I want to readdress the mother's testimony. The board is saying that the testimony was uncontroverted. I think that is a misrepresentation of the record, in fact. And even the board's own expert acknowledged that the mother wasn't credible. She talked in her own expert report about why she didn't consider the mother's statements because of all the discrepancies she had given. And this is located in Exhibit 7, AG 0094. In 2 spots, she specifically states, in the consumer complaint and interview, the mother described her recollection of events. She said the subject never asked the patient's history or if he was diabetic, that he, quote, asked what the patient had eaten, but not taken an inventory of the diet or medical history. Although she confirmed that her son had no past medical history, nor was he taking any medications, as was listed in his visit note from that day. She states that her son had drank a gallon of water on his way to the clinic and that she informed the subject about this, as well as a family history of diabetes, and this was acknowledged. However, per the chart note, none of the history is listed, and Dr. Lee did not mention these items during his interview. Dr. Lee states in both his summary and care response in the interview that an appropriate medical screening was done, and he was denied as having any chronic, the patient denied having any chronic or inactive medical conditions nor taking any medications. She also acknowledged that the patient's mother claims she told the subject and her son that her son had drank a gallon of water immediately prior to arriving at the clinic. But the Sutter records state that polydipsia, which is excessive thirst, was denied. And this is in multiple places in the Sutter records. Another issue is that the board wants to highlight Exhibit 16. Let's talk about Exhibit 16. This was supposed to be a response by Dr. Wood to a subpoena for all records. Now, our office provided the Deputy Attorney General with thousands of pages, or about 500 and so pages of records here. And that is not what showed up at hearing. What showed up at hearing was 48 pages. And what it came out to be was this: 48 pages that were in no particular order. No one was able to identify what document came with what email or what we were looking at when, who wrote a certain document. And not only that, the most offensive of all, the most offensive of everything was that the Deputy Attorney General represented this exhibit to be the documents that were provided by Dr. Wood, and they were not. What happened was the Attorney General's office took these documents, manipulated them.
Objection. Misstates the evidence outside the record.
Absolutely not.
Ms. Hendricks.
In the record.
Ms. Wagner, your response?
Where is it in the record? It's not in the record.
This is going to count against my 5 minutes, Your Honor. It's on page 5.
Your Honor, I'll save it for argument. Let her just go ahead. Thank you.
Okay.
So the Deputy Attorney General admitted that someone in her office had taken this document, put it through some sort of program, and this then showed red line on the document. All I know was that they weren't the documents that were produced to the board. To the Deputy Attorney General's office. So there is absolutely no evidentiary value to these documents. They were manipulated by the Attorney General. They were not produced in the same way that they were not produced at hearing the same way they were produced to them. And there's absolutely no value to it. We don't even know what we're looking at. And so if we talk about the board's expert, the DAG highlighted that the ALJ only referred to one thing that the board's expert said about the standard of care. Well, let's talk about that real quick. The board's expert testified on the first 2 days of hearing that the standard of care was something which is a standard that she holds herself to, is essentially what the ALJ said. So on day 3, what happened was the expert came out to testify, and now for the first time, she used a reasonable person standard. And when I asked her about that on cross-examination, she said that she admitted she had a conversation with the Deputy Attorney General, went back, looked at the disciplinary guidelines, refreshed herself on what the standard of care was, and that's why her testimony changed.
Ms. Hendrickson, you've exceeded 5 minutes. So, Ms. Wagner, your final response.
Thank you. I just would like to reiterate the point. The true issues here in the case are the standard of care was violated. The proposed decision does not accurately reflect the evidence that was before the board, and that the proposed decision is inadequate to protect the public in this case. I don't want to get too sidetracked by other issues which appear to be attacking my integrity, the board's experts' integrity, the patient's mother's integrity. I will point out that innocent misrecollection of witnesses is common, if that's what counsel is pointing out, is some inconsistencies. That's very common, especially obviously in something that had happened under great trauma. But the point is that the board's, the proposed decision does not even acknowledge that the patient's mother testified about any of these things, or weigh that testimony against the evidence. So the weight of the evidence is against the proposed decision in this matter. And discipline is appropriate to protect the public. And I just want to point out, although it's not really relevant to this and it's more a personal attack, is this issue of Exhibit 16. The board, or the Attorney General's office, was provided documents from counsel that were from their expert, Dr. Woods, and they gave us all the documents, which were their paper documents, and we simply clicked on, as you can with the Word document, you click Show Edits. If you've ever had someone edit your writing, you put Show Edits, and it showed all the edits on there that counsel had made to their experts' written report. The attorney was making edits to the written reports of their expert. And all that can be done not in altering evidence, as they made it sound that the Attorney General's office would do such a thing. We took the documents that they had electronically given us. We checked Show Edits, and it showed all the edits of the attorney essentially writing the expert's opinion in this case to ensure that it fell within the very small category of one simple departure in the standard of care. That's simply not what happened in this case, and we would urge the board to reject the proposed decision in this matter as it goes against the weight of the evidence. The board has proven this case by clear and convincing evidence, and we ask that the public be protected by placing Dr. Lee on probation with appropriate monitoring. Thank you.
Thank you. Dr. Lee, you have the opportunity to address the panel regarding penalty. Do you wish to do so, sir?
Yes.
Okay, if you could raise your right hand, please. Do you solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You may put your hand down. And so I just remind you, if you'd keep your remarks to 5 minutes or less, and whenever you're ready.
Okay. First of all, I would like to thank you for thanks for the medical board and the judge give me this opportunity to address the case. This is a really sad case, and I feel very bad. Very sorry for the mother's loss for the trial. I want to let the board know is that I have been practiced medicine for 20 years. I was trained in internal medicine and pediatrics, and I've been working in the ER for more than 10 years. And after that, in order to help the ER overcrowdedness, and I established the urgent care. That has been more than 10 years. I'm a very experienced physician, and also I'm a very caring physician. I take patient care very seriously. I would say more than my own life. I treat all the patients as my own family. The other thing that we have been really involved in the community services. We not just in the medicine, and also we help the community we help the city to organize the sport events and help for the job corps to train medical assistants to provide jobs for the underserved populations. And this is a really sad case, and we try to looking back for every step of the case, we still try to improve and try to learn something from it. Personally, I attend the medical record keeping class, and also we train all our staff. We set up the new vital sign policy, and we train all the staff and how we repeat the vital sign and how to do the documentations. I have a big practice in Lincoln. I have over 3,000 patients. Most of them are seniors, and they rely on my care. I've been seeing them every day up to now. And also in the urgent care, we are one of the main urgent care inside Sacramento to take care of the underserved population, underserved medical population. So I'm begging for the medical board and just give me the opportunity to continue my practice. And I don't want my 3,000 senior patient in Lincoln lost the primary care physician. Because once I'm put under the discipline, and I'm going to lose my privilege to serve those people. So that's one thing I want to address to the board, and I'm pretty confident that I'm safe to practice, and we have been training all our staff, and the whole practice environments and the whole documentations has been improved, and so I try to prove to the board that I will continue to do better, and I try to please give me the opportunity to serve my patient. Thank you.
Thanks, Dr. Lee. So that concludes argument. Turn it over to the for questions. First, Dr. Lewis, do you have any questions?
Yes, I have several questions, and respect to my other colleagues, I'm going to try to be brief, and maybe the person I question can be also brief. My first questions go to Ms. Wagner. Ms. Wagner, and Judge, you'll let me know if any of these questions are not in the record, please. You can just stop.
Sure, sure. Okay. And also the attorneys can object as well.
Oh, good. That's fine. Ms. Wagner, did you, or in the record, or did you have a chance to review the standard operating procedures or the standard operating procedures for MA or the operating procedures for the urgent care in your review?
I think I don't know for sure if Dr. Lee's counsel introduced those eventually at the hearing. But I think something related to that was entered, but it may have been that they corrected that and did it after this had happened. I really don't remember the details about that. Perhaps Ms. Hendrickson remembers. There was some documentation, but I don't know if they created that policy after this happened or what happened.
Okay, it's very important to know that, to understand how this urgent care operates, because every urgent care has a different set of SOPs, and also the SOP for the medical assistant different of what.
Would you like me to answer?
Yeah, I'd like to have an answer from somebody.
Yeah, please let me answer. They were at hearing, the urgent care's policies and procedures were under Exhibit Tab D, and what was decided was that the other documents, I'm sorry, no, I apologize. One moment. They were under Exhibit Tab H, forgive me. So we had the entire clinic's policies and procedures manual. What ended up happening was because it was determined that anything outside of the urgent care policy that was in place was irrelevant to the allegations, only pages 1, 2, which are the cover pages, which demonstrate that these policies and procedures were in place prior to this patient encounter. And then the patient page 8 was admitted, which was the actual repeat vital policy that was already in place before this encounter. Does that answer your question?
Yes, I think Dr. Lee probably will know even better about what is in place at that urgent care. But I want to finish with Ms. Wagner and then go on to Dr. Lee, if I may. Ms. Wagner, can you just clarify for me? I wrote this down and I want to make sure I understood this. did you say the increase in temperature cannot increase a heart rate?
We had the testimony from both experts at the hearing. So Dr. Lee had written a letter to the board explaining that he discounted the pulse rate of 142, that it was somehow related to a low-grade temperature of 99.9 degrees. And both of the experts testified that that is not accurate. And so I obviously am not an expert, but they both agreed on that issue, that was not in fact accurate, and that that was, inaccurate knowledge on the part of Dr. Lee.
Okay, I'm going to go on to Dr. Lee, if I may.
Yes.
Dr. Lee, your discharge summaries for each patient that leaves your urgent care, what does it usually say about if there are further problems? What are they supposed to do?
Okay. That based on different scenario, the discharge instruction for gastroenteritis, typically we tell them to maintain the oral hydration, looking for any fever, any abdominal pain. If the condition is worse and they cannot tolerate any fluid, and they go to the emergency room. That is the instruction was given to this patient.
Okay. And
In addition, if I may,
yes.
Sorry, forgive me. I'm down. If I may. In addition, Dr. Lee provided to the board a complete copy of the discharge instructions that were printed out and given to the patient. So there's a 1-page in the records, which the patient signed that she received these documents. But in Exhibit I, Respondent's Exhibit I, starting on page 5, I believe, just off the top of my head, there's actually another about maybe 6, 7, 8 pages of discharge instructions that were provided to the patient as well. And those documents were never provided to the board's expert before the hearing. So she acknowledged at the hearing that those would have been within the standard of care and adequate. She just wasn't provided them before then.
Okay. Dr. Lee, do you do blood tests or IV fluids in your urgent care?
We don't do IV fluid, and the blood tests based on the indication. If we need to do it, we can do a glucose check.
Okay, thank you. Let's see if I have any other questions before I move on. You've answered all my questions. So thank you very much for responding to them. I appreciate it.
Thank you.
Welcome.
Okay, Dr. Hawkins, any questions?
Yes, briefly, and for emphasis, Dr. Lewis asked my question of Dr. Lee, and that is, in this urgent care, do you have the ability to obtain blood tests such as potassium, glucose, et cetera? And the answer was yes, you have the ability. That was my only question.
Okay, Ms. Lubiano, any questions?
Hi, can you hear me?
Yes.
No questions at this time.
Okay, thank you. Mr. Warmoth, any questions?
Sorry, no questions.
Okay, thank you. Mr. Watkins, any questions?
Yes, I've got one. Good morning, Dr. Lee.
Good morning.
My question is, in the record, the mom disclosed that she told you that about his diabetic status and the family history. And my question is, based on the weight, the age of this particular patient, or would that have been something that we could have reasonably assumed? That's my only question.
Number one, the mom, when I took the history, and the mom denied any past medical history and also any family history of diabetic. So that is the you can see there was document on the chart, and she denied that my question about that.
Thank you.
Yeah.
The question is-
Okay, Dr. Yip, any questions?
No question. Thank you.
Okay, I've gone through the panel once. I'll check one more time. Any further questions from any panel members? Okay, hearing none.
I have one more.
Okay, go ahead, sir.
I forgot to ask Dr. Lee, do you have an electronic health record in place at your urgent care?
We use this. You can see that in the record. This is paper template, and after we using this template, we scan to the computer. So this is the system we use right now, and still that is probably one of the most common documentation system we use in the urgent care.
Okay, and the message for the DAG, is that a legal document in your opinion? I don't know if it's out of the record, but paper copies with check boxes, is that legal?
I think that the issue is.
Go ahead.
I'm sorry. The issue is that at that time, it was within the standard of care at the time Dr. Lee was using it to use such a form. You can, but you can't only use that and not, document pertinent positives and negative, not document that a recheck of the vital signs, not document tachycardia has resolved. So it's not just because they were a paper form and not electronic, at least at that time, that violated the standard of care. It was the lack of information in the documentation that was wholly inadequate in this case. If that answers your question.
So back to your question, whether it's legal or not. Yes, it's legal. It's many urgent care is using it even right now, and you can check on. I would say more than half of the urgent care right now is using the same system. And in terms of the documentation.
Dr. Lee, this is Judge Wong. I'm going to interrupt you. I apologize. This is really getting on beyond the scope of the question, which was directed to Ms. Wagner, and I think we're getting outside the record.
It's answered. It's been answered. Thank you.
Okay. And just for the record and the court reporter's benefit, those additional questions were by Dr. Lewis. Dr. Lewis, do you have any further questions?
No, I do not. Thank you very much, Judge.
And any of the other panel members have any additional questions? Okay, hearing none, this concludes oral arguments. The record's closed, the matter is submitted, and we are off the record. So Ms. Hendrickson and Ms. Wagner, as you may be aware, if we were in a regular hearing in person, what would be happening now is the court reporter would be filling out the forms and then they would be distributed. Since we're appearing through a WebEx, that obviously can't happen, but I'll get the information from the court reporter and then prepare the forms, and then OAH staff will send them out to the parties. If not today, hopefully tomorrow or within the next couple of days. So you will get the court reporter billing forms. Okay, so I will turn the matter back to Dr. Lewis for closed session.
Okay, Sean, you'll let me know whether we can, whether we can start? Is everybody exited?
No, not yet. Please give me a few moments to dismiss everybody involved in the second case here.
Okay, I'll go back on mute until you let me know.
Okay, the time I have is 11:22. So by the time I can get this done, let's say a return time of noon for all of the attendees. Just a sec here. I want to make sure I don't remove anyone I'm not supposed to. So yes, so all attendees, I see some already exiting. I've put everyone back into the attendee pool, and I'll now dismiss the attendee pool with a return time of 12 o'clock noon. We will be reopening the meeting. So you can rejoin from the same link you joined from earlier off of our agenda at 12 o'clock p.m., in which case I did see all the participants for the third oral argument. So when you come back at noon, we will do a sound check and do a roll call before we get started. Thank you very much.
Oh.